Defense attorney of two former senior officials of Gambia who are currently standing trial on 8 counts of economic crime said the defense counsel in the economic crime has the right to remain silent under the 1997 Constitution of the Gambia. Attorney Christopher Emmanuel Mani told the High Court in Banjul that he will only confine himself to the evidence that is relevant to the two conditions in making and upholding a no-case submission. Sehu Jammeh and Lamin Gassama have since denied any wrongdoing. Now, the prosecution has so far called 12 witnesses in the trial in their attempt to prove their case. Mafuji Sise has more of that in this report.
In his no-case submission, Attorney Menen said the facts in the case speaks for themselves and they do not require too much analysis. He urged the court to be so guided by the common law position as encapsulated in the English Logos Classicus. Lawyer Menen quoted Lord Lennon as in his book, where there is no evidence that the crime was committed by the accused, the judge has to stop the case. He said the statement of the offense must be an offense known to all, and the particulars of the alleged offense stated in the charge sheet serve the same role as pleadings in a civil matter, and evidence that is at variance with the particulars of offense goes to no issue. On statement of offense on count 1 of conspiracy, Attorney Menen said has looked at section 268 of the Criminal Code and the offense conspiracy to commit an economic crime does not exist anywhere and has not seen it anywhere. He said the offense of economic crime was created by a military degree and was amended by another degree. It was before the coming of the 1997 Constitution. He also stated that the degree is only saved by 232 transitional provision of the Constitution as an existing law, but only to the extent of consistency with the Constitution. He argued that any of its provisions that are inconsistent with the Constitution is null and void, and any provision of the degree which is not inconsistent with the Constitution will be null and void to the level of its inconsistency. When he read count 2, which is stealing by clerk contrary to section 245 of the Criminal Code, the attorney argued that the offense under 245A1 is simply the offense of stealing and the punishment section does not define the offense. The offense known to us is stealing. The punishment section is not the charging section. He said at the appropriate time they will look at the evidence of whether the prosecution lead evidence that the first accused person stole the money from Gambia Petroleum. He also invited the court to look at section 301A of the Criminal Code in relation to count 3, saying this will enable them to put the nature of the offense and the evidence into context. He said no such allegation or evidence was made against the accused persons that have been mentioned before the court, maintaining that no one has stated that the accused persons were responsible for any of their accounts. He said the Director of Finance of Gambia Petroleum, Amadou Kera, testified and he did not mention it. On count 4, he read the statement of offense and the particulars and said the depot supervisor Lamin Toure had testified and never mentioned any of these allegations. No other prosecution witness testified on it. On count 5, he said there is no evidence that any of the mentioned products were received by any of the accused persons personally. On count 6 of economic crime charge, Attorney Menen read the particulars of the offense and the statement of offense and said the issue of fraudulent intention does not arise, asking the question, how can a normal practice in an institution become fraudulent? Count 7 and count 8 are the same as count 6. Attorney Menen said particulars of each of the offenses have to be proved and any evidence that goes at variance with the particulars goes to no issue. It is the position of the law that in every alleged offense, the prosecution needs to establish two things, the mens rea and actus reus. The mens rea is the criminal intent. Once it is established that it is a normal practice, and once that is established that it is normal, the fraudulent intent is neutralized. Unless both are established in respect of each of the 8 counts, the accused persons cannot be called upon to open their defense in respect to each of the counts. In arguing this matter, Attorney Menen said he will take count 6, 7 and 8 together and 4 and 5 together, then he will deal with 1 and then count 2 last. Regarding economic crime charges, count 6, 7 and 8 Menen said what is crucial to this charge is the evidence of PW2, PW4, PW5, PW6, PW8, PW9, PW10, PW11, and PW12, and the exhibits tendered through them. He said the evidence adduced by these witnesses is integral. PW2 and PW4 are from the Operations Department. For Eyeafrica News, I am Mafuji Sise.